But we were. All right. Court of Appeal in the state district for the state of Florida is now in session. They in favor of the chief judge, that all persons that have been business before the court, all near to give attention, you will be heard. God save the United States of America, state of Florida, that's all.
Thank you. Good morning, everybody. Welcome to an oral argument session of the Sixth District Court of Appeal. We have two cases on our docket this morning. Before I call the first case, let me just say, gentlemen and lady, thank you very much for accommodating the last minute request to change the time. Really appreciate it. This is being live streamed on YouTube. If you haven't already silenced your cell phones, I would be much grateful if you did. To introduce the panel, I've already been introduced. I'm Dan Traber. I'll be presiding today. To my right, your left is the Honorable Carrie Ann Wozniak, and to my left, your right is the Honorable Joshua Mize. The first case on our docket today is Sheila Pierre versus State of Florida, 23-3308. Mr. Pennell, will you be making argument for Mr. Pierre?
Yes, sir.
How much time would you like for rebuttal?
5 minutes.
Great.
Please the court. My name is William Pennell and I represent Chile Pierre, the appellant in this case. As I indicated, I'd like 5 minutes of my time for rebuttal. As noted in our briefs, it's our position that the trial court committed 6. Cumulatively, they require a reversal of Mr. Pierre's convictions in this case. We acknowledge that the court provided the parties with a notice to specifically address harmless error as it relates to issue 3. I will make sure to address that. I think it makes more sense to address issue 1 first, because if the phone evidence is suppressed, then the harmlessness of that kind of goes away. Most of the evidence in the case did come from the phone. So it's our position that the trial court's first error was denying the motion to suppress the cell phone evidence obtained from Mr. Pierre's phone, because at the time that the phone was seized by Deputy Mercado of the Broward County Sheriff's Office, he did not have probable cause to believe that there was evidence of criminal activity on that phone. At the time that he seized, and obviously the court's aware of the probable cause standard, it's a probability, according to the 11th Circuit, a substantial chance that evidence of criminal activity would have been discovered. At the time Deputy Mercado seized the phone, the phones of all 5 or 6 individuals at the body shop. He testified that he didn't seize it based on any particularized suspicion, but all of them were around the car, and it was standard policy to take the phone before they transported them to the sheriff's office.
So it's the precedent of this court. I think it's the Hickman case, and this is just applying a Florida Supreme Court precedent. The officer's subjective view is not important. So say he seized all 5 of those phones and in his head did not, have a view that would give him probable cause. And if he didn't have probable cause as to the other 4, right, that ended up not mattering if there was objectively probable cause as to the phone that subject of suppression was appropriate, correct?
I agree with the court's analysis, other than it is an objective analysis, but it has information in possession of him.
Information in possession of him, but he doesn't have to realize it gives him probable cause.
Correct. If he misbelieves that he does not have probable cause and he actually does, then suppression should be denied. So I agree with the court on that. In this case, the officer did not have probable cause under the objective standard because the information that had been conveyed to him by the members of the Orlando Police Department did not give him any information about, all he knew was that this vehicle was suspected of being in a shooting in Orlando. He did not know how the OPD had determined that the vehicle was involved in a shooting, how it had been tracked to Broward County. He was not given any information about the clothing description of the individual driving the vehicle at the time of the shooting. And in direct response from a question from the trial judge, he indicated that he knew nothing particular about the crime other than the vehicle identified as the vehicle involved, but knew nothing about a suspect being identified. So it's our position that he didn't have the particularized suspicion to Mr. Pierre, and more importantly, to the phone. And I think that's consistent with this court's decision in Jefferson, that says you can't just speculate there's going to be information on this phone that's relevant to the
Saw him
crime.
driving the car, didn't he?
I'm sorry?
Didn't the detective saw Pierre driving the car?
Someone driving the car in Broward County. And he saw.
He knows it's the car that was involved in the crime.
Yeah.
And he knows this, he drove the car.
Mhm.
And he saw him removing stuff in the car, right?
It did. I don't think that's sufficient. I think under Jefferson, there was far more evidence of that connecting the defendant and than the phone to the crime. And this court found at the time of the seizure in Jefferson, the victim was dead. The trail of evidence led to Jefferson's apartment. Jefferson was previously acquainted with the victim and was at her apartment on May 24th. Her body was found on May 26th.
He knows the car was involved in a murder a few hours before. He now sees just a few hours later, your client driving the car. And not just driving it transiently, but removing things from it as if he had occupied it. That doesn't give probable cause.
He sees multiple people around the car. He sees 2 different people driving the car. They attempt to detain one of them, and that person flees the scene. They do eventually detain him, but they see
But even if you see multiple people driving the car, seeing one indicates he was involved, very well could be involved with that car. In the hours leading up,
he
right?
could be involved in the car. He could be involved with that car.
More could be. It's very likely involved with the car. He's
So
driving it a few hours after.
He's
the
involved in the car 3 hours after the shooting, hundreds of miles away from the shooting. We don't know if people switch, there's a different driver. I don't think it rises to a probability that there's going to be evidence on his phone. Maybe probability that there's evidence in the car, but now I think you're speculating to go to his phone, pursuant to this court's decision in Jefferson. So it's our position that, when he explicitly says that he had no information regarding the suspect, that he's just doing a general detention and seizing phones of everyone at the scene, he doesn't have the necessary probable cause, the particularized probable
I mean,
cause.
that goes to the subjectivity, right? Whether he believed he had probable cause, or I get you. Maybe he didn't have probable cause as to all the cell phones, but those ones aren't an issue.
No, I know, I understand it, but
That's
objectively.
kind of a red, you said, that's a red herring to me.
Oh, okay, that's fine. I don't think him seeing Mr. Pierre nearby the car hours after the shooting, hundreds of miles away from the location of the shooting, with no information specifically from OPD that he's a suspect, gives him probable cause to seize the phone, maybe to search the vehicle.
Because I want to get you to the harmless error, because I want to make sure you have enough time to address it, and I have some real questions.
Sure.
In looking over the harmless error case law in preparation for this case, for something that comes up as often as it does, it's really surprisingly unclear and kind of difficult to work in practice to me. And here's what I mean by that. You take this case, for example, the state's only argument here was that the evidence was overwhelming. Right. Okay. The Florida Supreme Court has, as explicitly as you can, categorically rejected that as a basis for harmless error. And I think they actually have used the language in at least one case. We explicitly reject this argument as a basis to show harmless error. That's not an exact quote, but it's pretty close. And so if overwhelming evidence isn't sufficient, which the Florida Supreme Court has told us that it's not, what I'm wondering is, what is the proper way to evaluate whether improper evidence influenced a verdict? As I was thinking about it and understanding what the Florida Supreme Court has told me you can't consider pretty clearly, I really struggled to think conceptually, what other good way is there to evaluate the question? I mean, if overwhelming evidence isn't right, what's the right way? And I really didn't see a clear answer in the case law, which is surprising for something that we deal with on an almost daily basis. So I noticed in your reply brief, you responded to the state by essentially saying that the evidence was not overwhelming and that you think the evidence favored your client's theory of the case, which you took the other side of the argument, but you actually kind of bought into their overwhelming evidence framing by saying we disagree, the evidence was overwhelming. So can you take me through your view on what is the way to evaluate this?
Well, the court is right that the Supreme Court has explicitly rejected the overwhelming evidence standard. The only case the state cites is the Smith case, the second DCA in 1998. And what that court says is the harmless error analysis provides a useful tool to shield our criminal justice system from unnecessary retrials in which, quote, negligible error would not change the result. They go on to say the harmless error doctrine should not, however, become a sword used to deprive even the most guilty defendant of a fair trial. We don't think the evidence is overwhelming, but if the court does think the evidence is overwhelming, that second sentence says that doesn't mean it's harmless.
I get it. I agree with you.
So-
Overwhelming evidence.
So they're talking about negligible error. So
How do we frame it?
I think a negligible error would be something more like an improper ruling on a hearsay objection to something that wasn't very important. Or maybe in this case, if you had a photo of another handgun, maybe that could be harmless. But when you have a photo of an assault rifle, a video of Mr. Pierre exposing and bragging about his genitals, and text and audio messages about dealing in firearms, I don't think given the substantial prejudice from those three things, you can,
Well, how do we evaluate something like that? So I get the case law is pretty clear that evidence of guns unrelated to the crime is error to admit it. And I could certainly see it's not, in my view, it's not just whether it's something that should cause the jury to have a bias against your client. It's whether it's something that could, properly or improperly. In other words, even if a jury shouldn't hold gun ownership against somebody, if there's some percentage that might, it could be a problem.
right.
But you take like how prejudicial is it? Like you use the term assault rifle. I didn't see anything in the record that showed why this is an assault rifle,
Sure.
as opposed to say any other type of rifle. And that seems to me to kind of play up the prejudice. So I guess I would say that seems to me to be a sliding scale. We're like, well, how inflammatory was the error? And that seems to create line drawing issues. That's what I took from your analysis of the second PCA case. Well, how inflammatory is the error? How difficult is the error? And I don't know how to draw that line. And I'll ask in this case specifically, like what made this an assault rifle as opposed to a rifle? Were there some characteristics you saw that made you classify it as an assault rifle when you argued to us that it was particularly inflammatory because it was an assault rifle?
Well, I'm certainly no gun expert, and I'm based on previous oral arguments, I'm aware that you are. So I would first point out that the state did not, or are calling it an assault rifle themselves. So I think the common understanding of a person viewing that firearm would believe it's an assault rifle. And based on my viewing, it appears to be similar to weapons that have been used in mass shootings and things that would likely to inflame jurors. It does not look like a pistol that generally people look upon as something that is used for self-defense or protection. It also doesn't look like an old school hunting rifle that you're looking like to shoot a deer with. So I think that's pretty clear from just looking at it. The contrast between the photos of the Glock and that photo are pretty drastic.
If I look at DiGiulio, and everybody seems to agree that that's where this comes from, it talks about the test being, it didn't contribute to the verdict, or alternatively stated that there is no reasonable possibility that the error contributed to conviction. It's weird for me that we can't consider overwhelming evidence in that calculus. So I wonder if the Supreme Court's admonition that this isn't an overwhelming evidence test means it's not exclusively an overwhelming evidence test. For example, say your client, and I know he didn't do this, I'm just going to use it as an example. Say the second that he was arrested, he confessed. And that moreover, in this particular case, there was 17 different angles of high-res video showing him actually shooting Miss Forward. And the same error of showing this extra gun occurs. How could we not factor the confession and the 14 different angles of high-res video showing the shooting?
Well, I agree with the court that you have to look, after they say overwhelming evidence standard, they say you have to look at the admissible evidence and the inadmissible evidence. So they are saying it's not solely an overwhelming evidence case. You have to compare. But what I think they're saying is what the court is saying, and what the Smith court says is, in a different case, this would be harmful, but in this case, we have a confession from the defendant saying he engaged in sexual activity with a 6-year-old because he, quote, was unable to resist her advances. So it's kind of hard to ignore his own words that he did have sex with a 6-year-old. And, that's a different situation. We don't have that here. We don't have a confession. We don't.
Well, in this case, you have, oh, go ahead.
No, I was just going to say that's the overwhelming evidence framing, though. You're explaining as to why the evidence is overwhelming there, but not here.
What I think Judge Traver is saying, and I think what the cases bear out is, if it's even more than overwhelming, like it's
really overwhelming.
I don't know what to call it, but indisputable. I mean,
I'm not being flippant. It's
no, I agree with you. So I think the way the cases bear out and what makes sense is harmless error would be more appropriate in the case where you have a confession, where you have an eyewitness, especially an eyewitness that doesn't have a motive or bias in the case.
Let me cast it to you this way. If we're going to look at the effect on the trier of fact, We're going to look at the contributing. It's not mentioned during opening. It's not mentioned during closing. The entire case is about an effort to establish that your client was the man in the jogging suit and the black Impala. State does a good enough job of that trial counsel effectively concedes the point in closing, that he was that person. And the theory was there must have been somebody hiding in the back seat. There is a comment that multiple women on the jury were aghast, which is a great word, at seeing your client's genitals, coupled with the fact that the question placed before them for their deliberations was whether your client was the shooter, not whether he was there or what he shot the victim with. It suggests that nobody needed to watch this video during deliberations. Also, if you look at the transcript, it shows that clearly the assault rifle wasn't shown to the jury during trial, because you can see in the video, it says, and there is the other one. It doesn't say that in the transcript. The trial court says, you were reading my mind. The state said I stopped it. So it's pretty clear to me that the jury didn't see the assault rifle during the transcript. I wonder, when you look at all of that, how there was any effect of an error on the jury in this case, no matter what test we look at.
I don't read the transcript the same way. I don't think it's clear that they didn't see the assault rifle. I'm guessing that, I believe the record reflects that it went back into evidence and they had the ability to view it. So I don't think we can.
I'll leave you with one more thought, because I didn't catch it until literally yesterday, when I was just finished my secondary review of this transcript another time. At the very end, go back and check. Looks to me like trial counsel didn't object when the trial court said, look over all of the evidence after the trial and decide what you're going to go back to and what's not going to go back. You know, my experience in criminal felony judging is that you always had the lawyers get together afterwards and decide what they agreed or didn't agree to go back. Obviously, we don't send guns and bullets back together for a safety reason. We don't send fentanyl back.
Right. But they're sending a video back.
But if somebody says, who had objections to the entire video being shown, then says, I don't object, and the video is going back, I wonder if that is an invited error at that point. I'm sorry to spring that on you, because I just caught it yesterday.
I think certainly not. I think at that time it's a futile objection for the trial, and his lawyers making an objection to judges leaving the bench and not addressing his redaction objections.
I'm not sure that's the case, though, because 3400 is a discretionary rule. So 3400 basically says that the trial court may send back exhibits. It doesn't require the trial court to send back exhibits. So there's nothing that suggests to me that the trial court at that moment couldn't exercise its discretion to say, for example.
We're suggesting that the judge is going to, at that point, not let the video go back after they were arguing back and forth.
Sure.
Repeatedly, and she's going to change her.
No, I don't think so. I think it's more along the lines of she would do what she did. And this is only if you buy into my reading of the transcript, which.
It's 11:07 if you want to address it on rebuttal, counsel. So 11:07 is the, when the video is shown, and there's a colloquy with the court afterwards that it does seem like it appears they pressed stop before the rifle was shown.
And there's just the rest of the video has his audio over the top of it, and not when he says, and this is the other, which is when the 2 seconds of the rifle is on there. I realize I'm eating up your rebuttal.
No, I understand. I feel like,
but I would say also
I feel
that,
like we're guessing now that they didn't see the assault rifle, and when the judge permitted the entire video to be played, and now we're guessing that it wasn't shown.
I think it's pretty clear.
Counsel,
Take a look at it.
I would think it would be most useful to maybe glance at that page of the transcript so you can address it specifically with us, because the judge just called them up and there's a colloquy where they appear to be talking about the fact that the video was stopped before the rifle came. The portion of the discussion of what evidence was going to go back, that's on 1281 and 1282. So maybe having looked at those pages in the transcript.
Thank you. I'll say that for a
conversation.
Thank you.
May it please the court. My name is Richard Palace. I represent the state of Florida. To get right into issue 3 here, it is our position that this is harmless error. And I think opposing counsel mentioned earlier about the hearsay cases being possible examples. And when I evaluate that kind of case law, when it comes to these types of evidentiary rulings, I realize, Your Honors, that 403 and 402, the case laws, we almost have a dearth of it when we're bringing in whether it's harmless in a lot of these, except for some of these firearm cases that were, of course, quoted in both the initial brief and reply brief. But I recall reading on the hearsay cases, when we're talking about the reasonable possibility that it affected the verdict, there's case law that speaks on whether the error is unimportant in relation to everything else the jury considered on the issue in question as revealed in the record. And that's how I sort of look at this, is whether this evidence comes out to being unimportant in regards to everything else we have.
Does that essentially come down to overwhelming evidence?
I believe overwhelming evidence is part of this analysis, Your Honor. The state acknowledges that, of course, under DeGuilio, all of our harmless error case law, overwhelming evidence alone is rejected. But I believe overwhelming evidence plays a part in whether this evidence is unimportant. If where we have here, almost so much of the case that the state focused on was about actually hyper technical details as to how defendant's phone started in the South Florida area, traveled up, laid in wait at the victim's apartment complex for 30 minutes, then was at the murder scene, and all of the camera footage that we have showing someone in this tracksuit, this distinctive tracksuit that multiple law enforcement officers all testified to noticing.
Does that essentially come down to overwhelming evidence and the improper evidence wasn't a major feature of the trial? Is that kind of a two-parter?
Yes, Your Honor, that is part of it, because at least when I looked into all of the case law cited regarding, at least we were looking at 402 and 403 objections, whether we were looking at cases like, I think, Green, Matayer, Jean Bart, and Downs. In some of those, we had issues where, I think it was in Downs, there we had the firearm was irrelevant because the murder weapon, I believe, was not automatic. It was an automatic weapon found. I believe this evidence was actually argued in the state's argument as indicative of guilt in the particular Downs case. And the jury wanted depositions from witnesses of which, as acknowledged by the court, had holes in what they looked at. Further, the victim did not identify the defendant at first in that case. I move into the Jean Bart case.
We're just looking at the rifle at the end of that video. Do you concede we're on 401 as opposed to 402 or 403? I mean, I just don't see the relevance of a gun that wasn't involved in the shooting.
I believe we are looking at relevance, and that's what most of the case law stops on, whether or not
Right, so we're not really looking at prejudice in the context of anything other than harmless error, whatever that test might be.
Yes,
Is that
Your
fair?
Honor.
Okay, so if we're looking at just it being a mistake, an error, then I think we're right into the harmless error analysis. Do you agree?
Yes, Your Honor. If we agree the gun is, of course, not relevant to this case, that doesn't make any fact more probative or not, at least regarding material fact, we go straight to harmless error. Because if we prove relevancy, of course, we have to prove that was not substantially outweighed by the prejudice here.
I know you didn't write this brief, but what's the state's burden as it relates to telling us what the harmless error is?
I mean, our burden is, of course, showing beyond a reasonable doubt that this error did not affect the verdict, and us then meeting the reasonable possibility that it did not affect the verdict test. Our burden only starts there. Burden is otherwise on the appellant to show the error. And while we did not touch as much on the relevancy, touch as much on the prejudice of that particular firearm, I mean, goodness knows the state wanted this to get in just to talk about the multiple guns here and the fact that we have two different Glocks that appear in some of our footage. I think that they ended up not, if that comes out that they stopped playing this video, then it does not matter. But of course they say, here's one, here's another one. The jury might wonder, what other guns are we talking about? But
So can I ask you that? I take your point about kind of the overwhelming evidence plus this particular evidence wasn't a feature. That I can see why that would make some sense. I want to talk about whether you made that argument in your brief and whether you had to. And so I just re-looked at the brief to refresh my memory.
yes, Your Honor.
And you really don't make that argument at all. You definitely make the overwhelming evidence part. There's several paragraphs where you say And it seems to be a pretty straightforward overwhelming evidence argument. I mean, the first line of your harmless error analysis is the evidence of appellant's guilt is overwhelming. And then you've got several paragraphs of all the evidence that you view as overwhelming, which I get. There's really nothing in here explaining, I'm not saying this means you're wrong, but there's nothing, at least in the brief, explaining why the video wasn't a feature, why you would meet that second prong of the test you just articulated. So it's the precedent of this court in Smith v. State and Middlebrooks v. State that we do not make harmless error arguments for the state. And that was based on the harmless error case law from the Florida Supreme Court saying it's the state's burden. And the state's burden means they've got to make the arguments, us making the arguments, and the court making the arguments for you, and it being the state's burden are irreconcilable. If it's the state burden, the state has to point it out to us and establish that it is harmless error. So if we were to accept your framing of kind of an overwhelming evidence, plus the improper evidence wasn't a feature, I get that. You didn't make that argument in the brief.
Yes, Your Honor.
Our case law says to you have to articulate it to us. Where does that leave us?
Well, Your Honor, acknowledging that case law, I'm familiar with those opinions on this. I would first to get into that, while of course we were not as artful saying anything other than overwhelming evidence, I think it's the second to last sentence of either the second to last paragraph or the one after it. We make a mention of other evidence of Glocks coming in through either, I think, the text messages showing the phone or I believe there were the phone calls, of course, discussing Glocks in that. And while, of course, that can play a part in this being unimportant because in all the case law discussing those cases, if we have other evidence of the inadmissible evidence, then that plays into the harmless error analysis.
Forgive me, some of the rifle.
Oh,
right?
yes, Your Honor.
The rifle. There's nothing in here that I see. I'm looking at your answer brief. There's nothing explaining how or why the rifle wasn't made a feature or couldn't have been expected to influence the jury, other than to say the evidence was otherwise overwhelming, which you lay out your argument on that fully. But there's nothing you articulated a two-step test. Overwhelming
Yes.
evidence and plus the improper evidence wasn't a feature. And that test kind of, I can understand, that makes logical sense. That actually does kind of square some of the, assuming it was correct,
Yes,
does
sure.
square the workability at least. It's not in your brief.
If I remember correctly, Your Honor, I believe we still cited to the Duilio case in discussing the harmless error analysis in this. And some of our harmless error analysis or analyses, I believe, bleed together when we're discussing some of the other evidence in here from issues 3 through 7, mostly 6. I recall us discussing it with cumulative because obviously we're arguing here that we have no multiple errors. But in getting into that, Your Honor, I believe at least citing to the Duilio case, of course, puts the court on notice of what the full correct test is. That, of course, we're not just.
That's just the bare assertion we meet the test. That's not an explanation of why the rifle wasn't a feature. I mean, if just saying you meet the test is enough, then all the state's got to do is cite Duilio, and it's always meets the burden without actually articulating why the test of Duilio was met.
Yes, Your Honor, understandable. Of course, because that certainly just citing to a case and saying there was error, the defendant doesn't meet their burden at all when appealing their judgment and sentence. So I understand that, Your Honor.
Do you accept that Middlebrooks and Smith are right in the context that it's exclusively and always the state's burden to show harmless error?
Your Honor, I think before this burden should shift respectfully to those cases. I know I think we're normally playing into, if I remember the statute correctly, it's 951.051, but I might be off on my
There's like
numbers.
3 harmless error statutes.
They play into here. I know with my assessment of at least a decent amount of case law, including getting sidetracked here with what's been getting discussed with all the Erling or fallout litigation, is that the defendant has to show prejudicial error. And, not just showing something was irrelevant, something was harmless, or I'm sorry, showing something was irrelevant, showing it was prejudicial. They also need to show how that actually prejudiced their case.
Wouldn't that be the opposite of it being the state's burden to show harmless error?
I believe it's almost like a volley, Your Honor. It is, they need to show that prejudice in order for us to then have our burden triggered.
So they have to show it's harmful. then that shifts the burden to you to show it's harmless.
Yes, Your Honor. At least that's how I read I think the 501 statute I'm referring to.
Okay, how do you square that with, all the Supreme Court's case law saying that once an error is shown, it is the state's burden to show that it's harmless?
Your Honor, I believe at least squaring up with all the Supreme Court cases, I'm not sure if they looked at that, if that case law specifies it being a sole briefing requirement of us, delineating this particular argument that I'm making here now, specifically within.
Well, what they say is once an error is shown, it's the state's burden to show it's harmful. Okay?
Yes, Your Honor.
And so I won't be offended if you think Smith and Millbrook's are wrong. I won't be offended. But
Appreciated, Your Honor.
But to me, if it's the state's burden saying the court put before you, those two things cannot both be true, right? It cannot be true that it's the state's burden. And also, if the state doesn't do it, the court will do it anyways. So if it's not in the brief, like where's the, hey, if you I guess you fleshed it out as much as you can. I'm still having trouble wrapping my head around it.
Me too. It's a
Yeah.
little confusing from the standpoint that you've got DiGiulio talks about it being the state's burden, which to me suggests where you went, either notice or ultimate pleading facts.
Yes, sir.
It seems a little bit odd, and I appreciate you saying it because it seems a little bit odd to me that we would hold the defendant to all those waiver cases that basically say just a bare assertion isn't enough and not hold the state to it. I'm, I guess, a little bit confused by a variety of Florida Supreme Court cases, including Goodwin, Jackson, Hughes, that basically talk about us having an independent obligation to review it on our own. I don't know how to square that with it being a state's burden.
Well,
Yes, Your Honor.
no, I'm sorry. Go ahead.
I mean, obviously, I know we're getting into kind of territory of, courts taking on Anders on their own volition and the like. Obviously here, the Supreme Court doesn't overrule itself, sub silencio in these cases. But if they are mentioning courts also undertaking their own harmless error, I believe it still gives the state the opportunity to possibly flesh out its analysis more, at least in this case. I know I'm almost shotgunning these arguments.
Are you basically saying you're entitled to meet your burden in oral argument?
Your Honor, at
I'm
least
not saying you're wrong.
I think if we try to square DiGiulio with the Jackson and Hughes cases and the like, talking about the courts having their own, I believe that still gives the state its other shot here. And again, I would like to think that while we do not mention a few specific words in our brief here, still discussing DiGiulio, knowing its reasonable possibility, and focusing on overwhelming evidence. Here, we're mostly just keeping our focus on the fact that because this evidence was so overwhelming, there's no reasonable possibility that it affected the verdict.
Did you come across in your preparation for this or otherwise, there's a case that Judge B.L. Thomas wrote on the first called Thornby State. It's a 2019 case, and he basically said that, Ventura, the last time I think the Florida Supreme Court said unequivocally, we explicitly reject overwhelming evidence. That was 2010. 2019, Judge Thomas writes an opinion saying courts are pretty much using an overwhelming evidence test. He said they're using the overwhelming evidence test. And he said there's another test we see them using, which is basically a kind of a less rigorous test than the one you articulated, but two-part, which is that whether the defendant's guilt was established by other evidence unrelated, not the improper evidence, but a little farther unrelated to the improper evidence, which almost to me is kind of a sufficiency of the evidence test, aside from any evidence that was related to the improper evidence. That kind of speaks to me the way courts have struggled with this, because 9 years after Ventura, courts are still saying, yeah, look at all these cases using overwhelming evidence. Did you have any thoughts on his analysis of those two tests? Or
Your Honor, his analysis in Thorn, while I'm not familiar with that opinion, I know at least as recently as 2021, the first DCA had harmless error analysis from Judge Winokur. And I think it was the Schluck case that came out from there that was regarding hearsay. And that one regarding whether that evidence was unimportant with the verdict. So I think that plays into what Judge B.L. Thomas on that court was discussing. And goodness knows if that is a type of analysis that I would agree we would definitely meet here under Judge Thomas. But of course, if this court requires additional briefing on, of course, any of these matters, the state would certainly be willing to get into that, just because I know this court has its decisions in Middlebrooks and the like regarding our burdens. But I think here the court's struggling with all of this. I think as we build from DeGuilio, getting into Ventura and the like, and saying we're not solely overwhelming evidence, while that is true, it's not solely overwhelming evidence. I think in certain cases, if we can get into saying this is overwhelming evidence, we thus meet the reasonable possibility that the error did not affect the verdict.
Do you agree with reading the transcript that the video, the portion of the video showing the rifle was not shown in trial? And then counsel consented to the video going back? Is there any reason, I mean, in your view, does that move the issue? But it's because it wasn't shown to the jury during trial, so it's not error. And then when it goes back to the jury, there was consent, it was invited error.
Yes, Your Honor, if that is what the viewing of the transcript says here, then certainly it's waived error and there was nothing for the jury to view. I think it's important. The jury's question had nothing to do with that. The jury just wanted to review the medical examiner's testimony, and then it had some questions about the knowledge of whether the victim was pregnant, if I remember correctly. In this case, there was nothing questioned about this particular video. Of course, I can't get into what the jury necessarily reviewed, but there were no objections made at the time that evidence was sent back, from what I could tell. I know that, of course, this video was heavily objected to. I will note, for one, assuming preservation, the discussions of redactions were not done in front of the judge. And when this evidence was then played, we didn't even have, while there was then another subject to prior objections and talking about how this evidence was damaging, there was still no additional, can we redact this? And if the state did stop it, then in theory, that portion regarding the rifle, whether an assault rifle or shotgun standard rifle, that's just not reviewed by the jury in this case, and there's no error to be corrected.
I guess we've gotten to this point in criminal felony courts in the district where we're sending back non-connected laptops to view video evidence, and that's become pretty common.
Yeah, sure.
But I just wonder if you're in a situation where that wasn't available, you of course wouldn't send back a laptop that was connected to the internet to allow the jury to do its own independent research. You would just basically, anytime that the jury wanted to see something, just like when they wanted to see the gun or hold the bullets or look at the cocaine again, we'd call them back into the courtroom.
Yes, Your Honor. Typically, at least with readbacks and everything, we don't send the court reporter back there with them. We bring them in here, and the court reporter will then do the readback for them there. So I believe that if they wanted to view this video again, we would probably have had it happen here.
Well, no, I mean, it went back with them, so they could have looked at it and we wouldn't know about it.
Yes,
and
sir.
that wouldn't have come back down to the court. But the issue is whether that, so if it went back to them, you could see why that might be error, right? But if there was no objection to it going back, and there was in fact, from looking up the transcript, agreement for it to go back,
Yeah,
that would make the error, not error, but invited error.
and I know this court has a prior opinion, I want to say either a year or 2 years ago, discussing whether subject to prior objection is sufficient for.
Zolo.
Yes, that case, discussing whether or not the statutory requirement of preservation and our common law preservations can, be reconciled in that case. And arguably under that, you would say that this is not preserved under that type of principle, I think, Your Honor.
Well, also, I don't think that would be, I mean, there, it's the issue is whether you have to renew your objection. Statute says you don't, Supreme Court says you did, but that presumes it's the same objection.
Yes.
Here, it's two different issues. One is the video being shown to the jury. And, that's one decision to which the trial counsel did object. The second is the discretionary decision of what evidence goes back with the jury.
Yes, sure.
So to me, it wouldn't be a renewal of the objection because that's not the same issue. That's a new issue.
I
And
understand.
there wasn't just a lack, it seems reading the transcript, there wasn't just a lack of objection, there was agreement. There was, we agree this can go back.
Yes, sure.
That would, anyways.
Which I guess would play possibly more into waiver or invited error at this point than be an actual preservation issue.
Just to confirm, the state's position reading this transcript is that the video stopped before the assault rifle was shown in the video.
That, Your Honor, that was not something that came to mind when I first went through this transcript, but when that question was posed during the topside argument, I went to go back in there and I see you read my mind. Yes, I stopped it before. That I know this video is only 27 seconds and the firearm is only, or the second firearm is only about 3 seconds of that before it goes back to his face, if I remember correctly. So it would seem, I don't see why they would stop it short to him returning the phone to his face, because that was what the state wanted to have in. So I would agree, Your Honor, that if they were to stop it somewhere, they would stop it at the assault rifle.
Thank you.
No, thank you, Your Honor. I see that I've gone into my time. So if there are no other questions, I will rely on the state's brief and I ask that you affirm.
Thank you. I give you an opportunity just to address those transcript pages that we sprung on you at the.
So I agree, the transcript on 11/7 suggests that the assault rifle was not shown to the jury. As the state indicated, this is a very short video. Generally in these transcripts, when the transcriptionist says you can't rely on this as an accurate depiction of what the audio and video is. So I still think we're speculating. Say that there should have been a separate objection. I think it's a futile objection when the trial court said as a whole, the video was admissible and walked off the bench when the lawyer wanted to make an argument about redaction. To say that another objection would result in a different outcome is, I think, not reasonable.
What if the objection was, hey, I object to that video going back. I would like that to be played in open court, and I would like the state attorney to stop it before the
He made that objection and she left the room. He said, I want to redact, and she says, no, I've heard it all.
That was when they were talking about what evidence is going to be presented to the jury, not what evidence was going to go
No,
back.
I understand, but I mean, as a lawyer, are you actually expecting a different, I mean, she didn't just say overruled or let me, or listen to his argument. She said, I heard it all, we're not redacting, and ran out of the room. I mean, this is an extreme example of a judge saying, I've heard enough, I'm not addressing this. So to me, it's a futile objection. I don't see any other way to read it. You know, he's just agreeing that he's not agreeing that he thinks it should go back. He's already made it clear he doesn't think the jury should see it. The judge has said the jury can see the whole video. He's just saying, yeah, nothing's been slipped into this that wasn't admitted. He's not saying explicitly, oh yeah, I agree that they should see this. He's saying, yeah, those were the 4 exhibits that were introduced, so it's okay. Yeah.
Do you want to finish up with any, we've asked a lot of questions into your time. Do you want to?
Well, I think
finish up
Judge
with any-
Mize is, you know, I think the reading of the cases where it says the burden's on the state, I don't think there's any other way to read it. If they have a burden, they have a burden. And neither in their initial brief, in their answer brief or today oral argument, have they explained why the firearm distribution, text messages and audio, why the assault rifle, and why the video of Mr. Pierre bragging about his genitals is not prejudicial. They haven't said it today and they haven't said it in their brief. I mean, of the things that a juror expects to see at a trial, I think a video of a man bragging about his penis being the equivalent of a gun is probably high on the list of things they don't expect to see. And the lawyer makes a
Was that
record.
chased out at all, though, by trial counsel's appropriate and good objections to the notion, and it goes to weight as opposed to admissibility? You can't tell that that's his hand on the gun in the other picture. You can't tell that that's his living room when it shows the Glock on
I don't
the
know.
ottoman.
They repeat it?
Yeah, so the response to I need to show his face in this particular video, face, genitals, gun, is the idea that the other Glock pictures don't have Mr. Pierre's face or any other identifying feature in them. You could say that one of the pictures wasn't a picture of Mr. Pierre's living room. The other one is a hand holding a gun. And the argument is, well, that's not his hand. How do we know that it's his hand?
Well, I agree completely with the court that the jury gets to see his face. We apparently the state wasn't able to do this, but we were able to redact the video in about 5 minutes yesterday. And we redacted the video where you see his face. This is after he displays his penis. You see his face, you see him walking over to the Glock and pointing to the Glock. So you see his hand, you see his face, you see the Glock. That satisfies the court's concern.
Counsel, I have two more questions for you, and I know we're over your time. But number one, do you agree with or I guess what are your thoughts on the test articulated by the state's counsel that it's not overwhelming evidence, but it's overwhelming evidence, plus it wasn't a feature? I'm not saying that was met in this case or they argued it.
Sure.
Just whether or not that's a decent way to look at it. And go ahead.
A feature. So, you know, it's so hard to say what a feature is, you know, I'm guessing that one of the, even if that's, I don't know if that's the appropriate test or not, but if it is, I'm guessing one of the things that each juror mentioned to their significant other when they got home is, I saw the defendant bragging about his penis on a video. So to say that's not a feature because it was a short period of time, I think is different than if it was like a hearsay objection. I mean, that's a pretty blatant thing. It's a pretty, so even if feature is the standard, then we have a long, multiple paragraphs of discussions about him dealing in firearms. It has no relevance. And the state hasn't explained today why it's not prejudicial or why that wasn't a feature. And all this stuff went back to the jury room. So now we're speculating that they didn't look at it.
So that kind of goes to your prior argument that maybe another component is how inflammatory was the error.
Yes, and Ventura, as the court said, is the last time the Florida Supreme Court addressed this, and they said you have to look. It says application of the test requires not only a close examination of the permissible evidence, but an even closer examination of the impermissible evidence, which might have possibly influenced the jury. And I think that's where the states failed to meet their burden. They haven't told the court in any shape or form why this wasn't prejudicial.
But last question I have here, I know we're over time. Your comment about the iPhone video, and this goes to a question I've been thinking about, which is when you say an iPhone video can't be edited, that's obviously wrong. You know, you can edit an iPhone video on your iPhone. There's numerous software programs to do that. Entire movies have been shot on iPhone. So the idea that this video just couldn't be redacted seems to not pass the common knowledge test. So the idea that it's a factual assertion though, right? So the idea, I know in this case that your client's trial counsel didn't get the chance to view it or, you know, to ask further questions about the ability to redact and run that to the ground. I get that. But aside from that, just this idea, even if it had been run to the ground, that wasn't an issue here. If there's some factual assertion that is just obviously wrong, like say the argument had been iPhones don't make phone calls, right? We would not on appeal say, well, that's a factual assertion and there's nothing in the record to dispute it. We would say, that's obviously nonsense. It's contrary to common knowledge that every cognizant adult has. iPhones can make phone calls, right? So this idea that like the video couldn't be redacted, I'm not saying it's on the same level as iPhones can't make phone calls. But I guess my question is, how obviously wrong does some factual assertion need to be before you would say, or we would say, this isn't the type of thing where we're going to say, oh, this is a technical issue or we can't go outside the record. The sky is not green, grass is not blue. Some things, it doesn't matter how confined in the record they are. We just know they're wrong because it's common knowledge. But when you say an iPhone video can't be redacted, where on the spectrum is that? And how far along that spectrum of, you know, a highly technical factual assertion to which we would obviously, you know, obey the normal, you know, idea that we can't think of things outside the record, and just obviously false things that every cognizant person would know are false, that we would say if that's in the record, it's obviously wrong. How far on that spectrum between those two things before we can treat it like the sky is green? And where does the iPhone redaction fall on that?
Well, if 10 is being the most absurd, then we're at 10. I think if the court's at an 8, we're good. But I think the record even supports the idea that there was measures that could have been used to preclude the jury from seeing the assault rifle. Because now we're disputing, because apparently, even though the defense lawyer is arguing for redaction, the state continues to argue for the whole video to be admitted. It doesn't offer at the time of the argument to pause it, but then later finds a pause button. So even if you don't have to redact it, you could pause the video at different parts to make sure they didn't see either the penis bragging or the assault rifle. So even if redaction, which, you know, actually cutting it up wasn't permissible, you do it all the time in court. You fast forward to 4 minutes of the video because the first 4 minutes aren't admissible. Or you don't show the last 10 minutes of a defendant's statement because he invoked Miranda. You hit pause. So it's absurd. It's a 10 out of 10 that it's absurd that there was no way to address the objection and show irrelevant evidence and prejudicial evidence to the jury. So for those reasons, we'd ask the court to reverse Mr. Pierre's conviction. It's not an overwhelming evidence test. And the prejudice from the evidence in this case is just too high, given the serious nature of the case. This is a shooting of a young woman with an unborn baby. And then you have a defendant mockingly calling his genitals a gun and displaying assault rifles.
I'm gonna ask you to wrap it up at this point, Mr. Pennell.
Thank you.
Thank you. Appreciate the time that everybody spent on this. You know, you never know what's going to be interesting to a court as it relates to a long and well-briefed appeal on each side. Thanks for indulging those questions. We'll be in recess.
I want to thank the court for sending the order telling us what to address. That's super helpful.
Thanks. We'll be in recess until 10:30.
We're gonna try and find a question for again, right?
No, I don't need to. Plug it.
Oh, okay.
Charged.
Yeah. Okay.
That's fine.
No, that's fine, that's fine. before we don't do it like this.
Right. Good morning. We're back in session. This is the second case. Before I announce it, actually, just because some folks weren't here when I did my initial announcements, I'm Dan Traver. I'm the Chief Judge of the Court. I'll be presiding over today's OA. To my right, your left is the Honorable Carrie Ann Wozniak. To my left, your right is the Honorable Joshua Mize. We're being streamed live on YouTube. If you would be so kind as to silence your cell phones if you've not done so already. This is case number 24-1357, Jimmy Rushing Jr. versus Sylvia Rushing. Are you Mr. Mockler?
I am, Your Honor.
Are you going to be arguing this morning?
I am, Your Honor.
You may proceed whenever you're ready.
May it please the court. When you serve in the military and you're on a retirement, on a pension plan, two things typically happen over time. Absent wrongdoing or something unusual, military service members get annual pay raises through a COLA. They also get time and grade, time and service pay raises, and they get pay raises as they're promoted. That is the norm. And that is the case in this case. In addition to your pay going up, as you serve more time in service, your percentage share of your base pay increases. So typically at 20 years, you're entitled to 50%. And each year thereafter, complete full year, you obtain another 2.5% share of your retirement. So at 21 years, you're at 52.5. At 22 years, you're at 55%. So your pay is going up and your share of that base pay is also going up. Okay. Master Sergeant Jimmy Rushing filed for petition for dissolution was in April of 2013. He retired in September of 2018, wherein he added 6 additional years, full years of military service. Now that's a period of only 5 years and some odd months, but he crossed 6 thresholds during that time period. So he went from being an E7 with 18 years of service to retiring with 24 years of service. The supplemental final judgment in this case violates not every rule in the book of equitable distribution, but almost every rule. And it violates them blatantly and inexplicably. So one of the black letter rules of equitable distribution is you can't modify equitable distribution. That's every case that's ever been heard. No case says otherwise. No case in the history of Florida law says, well, you can modify equitable distribution if you feel like it, or if somebody's pays late or does something. It's non-modifiable. Black letter law. What does this case do? Well, it modifies equitable distribution. Another in the more niche area of pension division, this case violates another black letter rule of law for equitable distribution, which is that a court may not award post-divorce accruals of benefits, such as time and service, time and grade, pay raises, raises in rank. Somebody could get divorced as a captain and retire as a colonel. The former wife wasn't married to the colonel. She was married to a captain, or vice versa. The former husband wasn't married to a colonel. He was married to a captain, whatever the case may be.
Is the parties' marital settlement agreement as it relates to your client's military pension unambiguous?
It is absolutely unambiguous. And here's what
we should talk about: the plain language of the agreement as opposed to the other considerations that you've been discussing so far.
Okay, so the perceived ambiguity is between 2 different clauses. One saying that they will be divided pursuant to 28 USC 1408, which is the Service Member Civil Relief Act, which simply says that you're.
I didn't understand your colleague to be arguing that there was an ambiguity in front of the trial court. I understood you both to be arguing that it was unambiguous. Is that fair?
My view is that it is unambiguous. What particularly concerning that clause And also concerning, our position is it's not ambiguous because what it tells us, right? And the former wife is going under substantial change of circumstances theory. She literally pled in her pleadings that there was a substantial change of circumstances. And she expressly asked for to award the retirement as of his date of retirement, not as the date of the divorce, which was 5+ years earlier.
If we see this your way, do you believe that there is authority for us to reverse and remand under the existing petition?
Yes.
Okay, what does that look like?
The issue is that the remand should make clear that the court is not permitted by discretion for any of the reasons that she found to read out of the final judgment that the retirement pay shall be calculated at the salary, right? So we need a salary and rate attributable to the former husband's rank at 18 years, comma, which is the rank and years that the husband had attained at the time of filing of the petition for dissolution of marriage. So we had no consideration of the salary, no consideration of the rank at 13 years. The court awarded, 2013 at 18 years. There was no consideration of that. What the court awarded was at 24 years of full retirement at his actual retirement date in September of 2018.
Is the directive then that it would include a revised military pay order that includes those factors?
It necessarily must, yes, and it must include an account for the salary and a rate attributable at the rank of E7 at 18 years, which is.
So it would be the percentage that's contemplated by the formula, which you guys agree on. It would be.
The percentage is correct.
Can you just let me finish? Just
Yes,
to
sir.
make sure that I have this correct. The hypothetical retirement date, which would have been April 11th of 2013.
Right,
Husband's rank when the parties divorced, which was E7.
correct,
The former husband's years of service when the parties divorced, which was 18.
correct,
And former husband's retired base pay, which is 38,2251.
also correct.
Is there anything that's missing there?
Nothing's missing from that recitation.
Okay.
What would have been in a commonplace in a family law order is to include the 3822 in the marital settlement agreement. But the case law authorizes the court to do math to give effect to the terms and words that are in the parties' agreement. So in this case, it says the correct percentage of military retired pay to be paid to the wife using the formula set forth above, right? And, that's an and based upon the husband's rank, years of service, and retired base pay set forth above. We did no calculation of the retired base pay. The trial court literally read that language out of the agreement, read the rank and years of service out of the agreement. The supplemental final judgment vitiated every important term of the agreement as it pertains to the husband's retired pay, except for it's a correct percentage. But what we're asking this court to correct is the percentage of what? The percentage of, I submit to the court, should be based upon the husband's ranks, years of service, and retired base pay. So you need a percentage of something. That's the 3822. That's the retired base pay set forth above. Okay. And how did we get there? Because there's a lot of fuss about using a high 3. But when everybody who retires in the military after, I think it's about 1980, is under a high 3. In fact, Master Sergeant Rushing retired at a high 3 in 2018. So it's always a high 3, but that high 3 is moving up over time as you increase your time in service, time and grade. So his high 3 in 2018 is a much different number than his high 3 should have been or was in his 2018 high 3 that he actually retired under is different from his April 2013 high 3, which we had an expert witness calculate and present to the court. So we're not asking for any type of windfall or strange calculation. We're asking the court to take the same high 3 retirement that actually occurred in 2018 and date it back 5+ years to that occurred in 2018 and date it back to 2013 when the divorce occurred, when the petition occurred. Other factors that to address is that this was not a situation where we needed to file a motion for rehearing. This was I'll call it a single issue trial, was dividing this military retired formula. And we argued ad nauseum throughout the entire trial, all of these points, and the court simply rejected them. They picked the former wife's argument over the former husband's, reading out everything we argued should have been considered and should have been in there. And that is not a case where the court, and conceptually, like when you have a mandatory motion for rehearing, that's because the court ruled on something it didn't have a chance to consider. Like, oh, you didn't put in the proper facts, or you didn't check these boxes, or something that was never argued before the court. Here, these arguments were all made, all on the record, fully developed, and a motion for hearing wasn't mandatory here. I also thought it's important to basically to try to come up with legal sorcery to get this modification, right? To impermissibly modify equitable distribution and award the wife a post-judgment share of his retirement. Two other arguments were that, oh, well, you had an affirmative defense a couple of pleadings ago that was withdrawn and replaced by an amended answer by new counsel that took out that affirmative
Yeah, but
defense.
it's an unambiguous agreement. I don't know why that matters.
Agreed wholly. And the other one is that, oh, well, you didn't pay while we were during the dispute, so we get to modify and take a higher percentage then. That is not the remedy. The remedy is you order retroactive at the correct rate, not that you impose a punitive measure and modify equitable distribution. The case laws, every case that's ever considered, whether you can modify equitable distribution based on misconduct, says no, you may not. Every case in the history of Florida law that looks at that issue says no. So we're dealing with, there's actually a lot of clarity in this case. There's so much clarity that there's a nearly identical case called Lawrence. I believe Lawrence is out of the 5th DCA, used to be here. Now it's not binding, but there's no case to the contrary. So I would, suggest it's at least highly instructive, if not binding. Well, not binding on this court. I'm sorry. It would have been binding on a trial court. But in any event, Lawrence teaches us that where you don't account for the post-judgment, post-divorce accruals of benefits, pay.
Kelsey, you're telling us a lot about how military pensions work. And I get that, the settlement agreement here mapped pretty closely about how military pensions work in the absence of a settlement agreement. But it could have also not, right? If the settlement agreement had said, we split the pension 50-50 as of the time he retires, that'd be enforceable too.
I agree 100%.
Yeah, so I guess what I'm saying is, all the explanation you're giving us about how military pensions work, while, interesting, it seems to me to be completely irrelevant, right? It's just what the agreement says. It so happens that this agreement utilized language that was close to how military pensions work without an agreement, right? In the absence of an agreement. But that's just a coincidence. If they want to alter it, how military pensions normally work, they can. So is it relevant how military pensions normally work, or is it just solely relevant what this agreement says, and that's all we should think about?
I believe how it works is relevant in the following ways. I agree with the court as a basic principle. This is a contract. This is a contract interpretation case, and the court should apply and interpret what the parties agreed to. But when I discuss how do pensions work, it's because it's all tied into the language of the agreement, which is tied into how pensions work insofar as we have things like based upon the husband's rank, years of service, and this is the key word of all, retired base pay set forth above. The retired base pay, the relevant retired base pay is April 2013. That's what's contractually bound. That's unambiguous. And that's where the court needed to do some math and put a number in. We did the math. We submitted the math. We had substantial competent evidence that was based on the military pay charts. And they say, no, we get it at 2018 when he retired. That flies in the face of the agreement, the plain letter of the agreement, the plain language of the agreement, the words of the agreement, and basically almost in the entirety of the agreement, it flies in the face of what the parties intended, because like Lawrence, the parties intended to split it 50-50 as of the date of the divorce. That's the key. They intended to split it 50-50 as of the day of the divorce. And all these words that were read out are important. And as this court as well, where you're not allowed to read out the core language of the agreement, I'd like to reserve 5 minutes and 56 seconds.
Thank you. Mr. Pierce.
Thank you, Your Honor. May it please the court. The appellant stated that the final judgment violates every rule of equitable distribution. He said it was black letter law. Said that as far as the pension division, there should be no award of post-divorce rule. Judge Mize asked whether or not the parties could have drafted a contract that close to the military, but actually not the military. Of course they can. That's the next case. Now, there was also a question whether or not there was an ambiguity. We both argued that it wasn't. We were both incorrect. The lack of clarity in this contract, where if we follow appellant's position, the tail wags the dog. Because if we're going to look at the words, it specifically states, effective on the first day of the first month following his retirement from active duty with the United States Air Force, and on the first day of each month thereafter, the husband shall pay or cause to be paid to the wife as a property right from the husband's United States Air Force retirement pay, an amount of his disposable retirement pay as defined in the Uniformed Services Former Spouses Protection Act. Those words have meaning. And if that is the case, that is what it should be divided in accordance with that. And there was a formula that was given.
Do you just stop there?
I'm sorry?
Do you just stop?
Absolutely not.
All right. So when you talk about the rest of that paragraph, specifically the wife's percentage share of the husband's disposable retirement pay shall be calculated at the salary and rank attributable to husband's rank of E7 at 18 years, which is the rank in years that the husband had attained at the time of the filing of the petition for dissolution. How do we get to the trial courts and your chosen interpretation of that language without completely reading out that verbiage?
I was going to get to that.
Please.
There's the ambiguity. It's because of the percentage that's used in the first part, and then you look at the second part. The trial court realized that. The trial court even asked, don't you see an ambiguity? Both parties said no. Okay, but when the trial court brought it up, and
I mean, I'm inclined to agree with both of you guys that we can look at this particular provision of the marital settlement agreement and give faith to every word that's in it, as opposed to selectively reading some words out and other words not out.
I would have to disagree, and here's the reason why.
But you understand you're disagreeing with both your motions in limine and your position at trial.
Well, not,
You specifically said, and correct me if I'm wrong, we don't even need to hear from this military pay expert because this agreement is so unambiguous that we can just look at what it says and apply it.
based on a reservation of jurisdiction, that's correct. Okay, that's based on a reservation of jurisdiction. The reservation of jurisdiction was solely to send a percentage to DFAS. That's what that is based on. Now, as far as the language is concerned, although the court just stated, well, we can just go ahead and do it, actually we can't. Because if we look at 143 over AD as far as the active duty, that gave us the 28-point percentage. That's the fraction. That's the fraction that the appellant wants to apply in the retirement portion. The expert said that is the number. Well, if you actually follow the appellant's argument, it would actually mean that the appellee should receive 33.33%, as opposed to the 24.83%. That's a 25.5% haircut that the appellee would take. No one signed up for that. That is why there is ambiguity there. When the expert is saying that the correct number denominator is 24.83%, But the calculation below shows that it is supposed to be 33 1/3. That's an ambiguity. And that's one that needs to be addressed at the trial. When the judge said, when the trial court stated that she saw an ambiguity, I mean, I think you can tell by the transcript, of course, my position was, uh-oh, she's right, there's an ambiguity. So from that point, of course, you have to look at the intent of the parties. And that is why we looked at the intent of the parties with parole evidence. Now, not only that,
Do you agree that we're in the exact same position as the trial court was as it relates to analyzing this contract?
that's what the case law states.
All right, so again, I guess I go back to the question that I asked before, that statement in the marital settlement agreement about how the wife's percentage share of the husband's disposable retirement pay shall be calculated. How do we get to your interpretation of that contractual provision without eliminating that language entirely?
Well, here's what you have to look at. Here's what you have to look at. There are two, at least in my eyes, as I'm looking at it after at the trial. These paragraphs cannot be read in complete harmony, just based on the language itself.
I guess I don't want to get you there yet. I just want to get an answer to my question about how you read it the way that you want to read it and that the trial court read it without reading it out entirely.
There's an inconsistency there. As far as reading it out entirely, if you're looking at the husband's disposable retirement pay, I understand as far as the calculation, and it would appear that it is read out entirely. However, I do not believe that it is completely read out entirely. Because I think there's a conflict there, Your Honor. I think there's a conflict there.
You're saying those two parts of the paragraph are just an irreconcilable conflict and that they.
I believe so. I believe that they're, because of those numbers, especially if you look at the percentages and you look at the percentage of the first where it's 143 over the total amount of active duty. The total amount of active duty that was calculated was based on when he actually retired. And that's what the expert said was appropriate. Again, if you take that, which is what they want to do, and apply it to the second portion, the appellee takes a 25.5% haircut.
So then your take on it is that because of that haircut, and I'll set aside for a second that the parties agreed that it was 24.83% the trial and that there was no dispute over that. So I'll set that aside for a second because it seems like you're trying to bring that back in. You're saying that because it's potentially could be more for your client means that the remedy is to read out the language?
No, I'm not saying that at all. I'm saying that there's the ambiguity there which needed to be addressed via parole evidence.
You didn't just say there was an ambiguity. You said those two parts are totally and completely irreconcilable.
Well, yes, they are completely irreconcilable, but if you go through, as far as the latent ambiguity, it can be read, if we look at the first part, we'll say, this is
When
not clear.
provisions are totally irreconcilable, and do you refer to that as an ambiguity? Is that how the case law works? Is that the next step in that logical process? Two provisions are on their own, each have a meaning, an unambiguous meaning, and those two meanings are totally and utterly irreconcilable. Do we then go to latent ambiguity? Is that the next step in how that works when you have two provisions that on their face are totally completely irreconcilable?
Is that?
Because that's what you said. You did.
What?
I asked you specifically, is it, you said it's not just ambiguous. You said the two parts of that paragraph are totally irreconcilable.
Yes,
When you have two parts of a contract that are just totally and completely, utterly irreconcilable, is, do you normally then go into a latent ambiguity process? Or is it something else?
If you have something like that, normally, depending upon when it's introduced, whether or not you're looking at clarification or a motion, I'm talking about at the time when it was drafted. But if you look at the way that it's drafted and you see two irreconcilable parts, I believe that, yes, you would have to look at it as ambiguous. But I understand what the court is saying as far as the latent ambiguity. It's when two things can be written, both parties are reading it, and it can be reasonably perceived in two different ways. I understand that, and this is irreconcilable. So.
The reservation of jurisdiction paragraph says that the calculation, there's a reservation of jurisdiction for the trial court to calculate the correct percentage of military retired pay to be paid to the former wife. And that requires that the mathematical formula set forth above be used. It also has language in there that says it's based upon the former husband's rank, years of service, and retired base pay as set forth above. What does that set forth above mean if it doesn't mean 18 years and E7?
As set forth above, as far as the equation is concerned, it's 143 over AD times 0.5.
Right. So let me ask the question again. So it says that it needs to be calculated by the correct percentage of military retired pay to be paid to the former wife. And that is based upon the former husband's rank, years of service, and retired base pay as set forth above. So if I understand your answer correctly, you're basically saying that all that is the mathematical formula. That was your position at trial, correct?
Yes.
Okay. What do I do with that language that says based on the former husband's rank, years of service, and retired base pay set forth above?
In the first paragraph, you have to include all of that. You have to include it in the first. It is mentioned in particular in the second, but in the first section, you still have to consider all of that as far as the calculation, because the Uniformed Services Former Spouses Protection Act uses all of that information.
So if we're just on the mathematical formula, which is the 143 divided by 288 times 5, where does former husband's rank come into that formula?
That's by the Uniformed Services Former Spouses Protection Act.
Do you agree with me that I can divide 143 by 288 and multiply by 0.5 without knowing his rank?
Yes.
Then how do I read that language not being there? What else could it possibly mean?
Could mean the second part based on that. But I'm sorry, did I cut you off?
No.
Okay. Now, the one thing that I wanted to address his first, but the one thing that I wanted to start with is Florida Family Law Rules of Procedure 12.530 specifically states that if you want to object to something, you have a concern or anything like that, you must file a motion for rehearing. The appellant has stated that this is a single issue. There is not a requirement to file a motion for rehearing. No, because the rule specifically states that you must file it. As a matter of fact, in Newton v. Augustin, this court adopted the 4th District's Top Valpo. And Top Valpo, the specific case stated that if you go and you do not file a motion for rehearing for any error that appears on the face of the judgment, you will have waived it. In this case, the appellant wants to say, this is just like the Lawrence case. This is nothing like the Lawrence case. In the Lawrence case, where it might be similar that there appeared to be a single argument, in Lawrence, the appellant actually filed something, actually served something on the judge, actually told the judge, something's wrong here, you're not following the contract. Also, in the Lawrence case, that judge actually wrote the order and the judge put in its interpretation of what the contract meant, as opposed to simply saying, this is the contract. In the case herein, the appellant did not file anything because he felt that it wasn't necessary. This isn't a sufficiency of the evidence. He didn't make that argument in the initial brief, so therefore he went that.
Where do you get in 12.530 that a motion for rehearing had to be filed as it relates to a legal challenge that was the sole focus of trial?
No, it's, as far as the findings are concerned, the
It's
appellant,
reserved for appeal a challenge to the failure of the trial court to make required findings of fact in the final judgment. A party must raise that issue in a motion for rehearing under this rule. I guess I just struggle to see where the trial court failed to make findings of fact.
61.0, he raised 61.075 and 61.076 as far as it being deficient. As a matter of fact, when he started off, he specific, as I read before, violates every rule of equitable distribution as far as pension division. And then in the brief, it brings up 61.75 and 61.076 and went in to explain how it should be divided.
Okay, I think I understand your argument. As it relates though to the contract, plain language being ambiguous or unambiguous or what it meant, you agree that that was raised fully before the trial court? I mean, you guys just had a whole trial about it, right?
Correct.
Okay. I just don't know how that would need to be raised in a motion for rehearing.
Any error, 6th District and Newton v. Augustin, any error on the face of the judgment must be raised in a motion for rehearing.
What if it was the whole thing that everybody talked about at trial? Isn't the point of a motion for rehearing to call the trial court's attention matters that it should have considered but didn't?
Yes,
So what didn't the trial court consider about the plain language of this contract that you guys had a trial over?
because if for some reason with what is being done right now and what was raised in the brief, stating that you should have used this, you should have used that, that should have been raised in a motion for rehearing. If you feel that the judge made an error or the judge did not follow the contract, the judge did not perceive a particular argument, that needs to be raised in a motion for rehearing. Otherwise, Newton v. Augustin has absolutely no meaning. And I think that Newton v. Augustin and Top Valco, they definitely do have meaning. So that's the reason why a motion for rehearing was absolutely required. Because even if you look at Top Valco, they went through and Top Valco said, those are very good arguments. As a matter of fact, we might agree with them. But you did not raise those arguments in a motion for rehearing. Since you did not raise the arguments in a motion for hearing, you waived them. And if Newton v. Augustin adopted that, well, the Top Valco is pretty clear as far as that's concerned. Let me go through, excuse me. Now, the appellant also stated they're not asking for a windfall. The demonstration of math would be that, yes, they are getting a windfall, and they would get a windfall if the,
So you acknowledge that if we were to accept your interpretation of the agreement, that's not how it works in the absence of an agreement, right?
oh, absolutely, right.
Yeah,
If there's not an agreement, you go directly pursuant to 61.075.
So in the absence of an agreement, she wouldn't be entitled to what you're asking for, right?
That's correct.
You
Right.
think it's there, but and you think it's the other side that's asking for a windfall?
Absolutely, because if they're going through and they're using the smaller percentage and applying it to the number that they want, yes, there is windfall, and that was demonstrated in the motion in limine, and that was also demonstrated in the answer brief, as far as the numbers are concerned. Because the share, if you decided that we're going to use the second part, that share would have been larger. Because as I stated, the appellee would take a 25.5% haircut. So that is, that would definitely be a windfall for them. I think my time is about expired, so what I have to do is request the court to the trial court. And I would have to rely on anything that wasn't.
Thank you.
Thank you.
May it please the court. There are two reservations of jurisdiction, either of which would allow the court to do the math and calculate correctly the appropriate share of military retired pay. There is a reservation on the face of the final judgment. And there is a reservation within the specific language about the division of military retired pay. And that reservation, the court has probably read it, but it appears in the record on page 340. The court entering this final judgment shall retain jurisdiction to calculate, if necessary, the correct percentage of military retired pay to be paid to the wife, right? So that's the percentage that we focused on and agreed to. But using the formula set forth above and based upon the rank, which we all agree was E7 at all times, years of service, which we also agreed on, and retired pay base. That's where all the agreement fell apart. And to affirm the trial court's order would be to read out the words retired pay base. And if the court were to look at, I believe it was 28 USC 1408. In the record, we talked about and defined what the retired pay base was under the federal statutes. And that is the pay base that's used to calculate the military retired pay, as I indicated initially, which was 2013 using the high three. And all we're asking is take it to leave it at 2013 where it was supposed to be under the parties' agreement on the final judgment, and don't take it forward to 2018 because he did retire under a high three analysis. So all we're asking is use the correct date and time and the correct retired pay base, which was the 3288. We're asking the court to remand with instructions to either adopt the 3288 outright, which I believe is the correct answer, but in any event to do what you're supposed to do when there's even a perceived inconsistency, which is to try to reconcile and give meaning to all of the terms of the final judgment. The Florida Supreme Court tells us that in Excelsior. And I believe the Fifth District, had a very similar opinion where it said the true meaning for the court to find and reach the party's intent is to construe the language, construe the party's agreement in such a manner as to give meaning to all of its terms and to harmonize those terms wherever possible. But the court's supplemental final judgment harmonized nothing. It did violence to the terms. Everything that had to do with, it got the percentage right, but everything percentage of what, it did violence to those terms. It eradicated them. It eviscerated them. They're gone. They're nowhere to be found. So I would ask the court to overturn that decision outright, as there was no contrary evidence and there is no contrary argument. If the court is to give meaning to using the correct retired base pay, the court has to instruct the lower court to adopt that number or determine that number again. But this court is in the same standing. This is under a de novo review. On a purely contractual basis, that reading, that order cannot stand. And none of the legal sorcery bases to uphold it, whether it be by a foregone affirmative defense or an admission against interest or parole evidence where there's lacking a clearly identified ambiguity, none of those can work. This is a straightforward calculation. The judgment did a pretty good job of it where it said, we're going to take this percentage, 24.83% times the correct pay base. And that was E7 as of 2018. I'm sorry. The 18 and the 18 years are getting me caught up. E7 at 18 years, which was as of April 2013, using those pay numbers as though he had retired at that time. I don't have anything further.
Thank you. We'll be in recess.